and I want to keep bringing it up because to me, it's not, this happens in every single aspect of your financial life, right? You've got your tax guy over there, you got your financial advisor over there, you got your insurance agent over there, and no one is coordinating it. So I want to be the glue.
Absolutely.
So just by being the guy who looks at everything and coordinates it, and I want to talk to those other guys too. Like I don't view those guys as competitors. I don't have the scarcity mindset. I want to coordinate with them so we all get better.
That's right. That's right.
It's probably worth, I would say it's probably worth at least another $10,000 a year in income just to have coordination between those guys because I guarantee you we'll find efficiencies just by talking to each other, right?
Yeah. Oh, another $10,000 benefit to the client?
Yeah, at least.
Oh. Oh, I agree with you in many client situations. Absolutely. Now, granted, I want everybody, not somebody that doesn't own a home and is just starting out in life, okay? That 10,000 savings might not be there for, but for people that have developed one or two pieces of real estate, some financial accounts. That's what Logan's talking about. That $10,000 number is not something that we just pulled out of a hat. It's very accurate.
Yeah, yeah. So we talked about last will and testament. Are there other documents as well that they need to have?
If somebody's going to put a complete estate plan in place, I don't like to use the word basic, but most Americans don't have an estate tax problem. Most people I talk to would prefer that their families didn't have to go through any court processes to be appointed a successor. Okay. So, in order to do that, clients are putting in place a revocable trust. And the word living, if you've heard the word living, all that means is that your document became effective while you were alive. Logan, some people confuse the revocable trust with a testamentary trust. And I've talked to plenty of people across the country, Logan, that say, oh, I've got a trust in place. And they show me their documents. And the reality is they've got a trust that's created through the instructions in their last will and testament. It's actually a testamentary trust. It's not a revocable living trust that avoids probate. It's a trust established after death to hold assets for beneficiaries, whether they're spendthrifts, minors, or special needs kids. Okay? That's not the same trust as we're talking about that avoids the court processes. That's the revocable. So the revocable living trust, financial and medical powers of attorney, nomination of guardian documents are widely put in place across this country. This nomination of guardian document, Logan, works in conjunction with your healthcare power of attorney because some care facilities want to know who's your guardian now that you can't make decisions. And your successor's got that document to work in coordination with the healthcare power. Something that's a little newer in our industry are documents dealing with what's to be done with your body after you're gone. Funeral homes want acknowledgement from the deceased whether or not you wanted burial or cremation, and they want your successor to basically show them a document that said what your wishes are as far as what you want done with your body, burial, cremation, etc. In community property states, a married couple will have a community property agreement. Why? Because in community property states, when there's the death of a first spouse, a benefit the survivor has is a full stepped up in basis in all of the highly appreciated assets when they receive them. Okay. You still have a last will and testament when you put in place all these documents. And some people say to me, Maloney, why the last will? Here's why. This will that's connected with your trust, in the industry, it's called a pour over will. And all that means is that the beneficiary of this will is your trust. Why would this pour over will be used after your death? For this simple reason. It's because after your death, when there was an inventory of assets done, all the assets that should have been in the trust weren't retitled. Therefore, the assets still in your name, and your last will and testament via probate will eventually direct that money into your trust, and your trust distribution language will control where the money goes. So I want you to hear that clearly. Many people that have estate plans, including a trust, don't have all their assets in it. Therefore, that last will and testament, which is still administered through probate, will be used.
Okay. So let's talk
Hogan,
about.
one more item, sir. And the other documents that are done are the deed transfers. Okay, getting all the real estate into the trust. So that's your robust estate plan. So if you've ever seen somebody's binder
Mhm.
with a married couple, there's with a single person, 7, 8 documents. With a married couple, 14 to 16 documents. And if I could add one item, all of those documents do a different job. They are not all part of a trust. A lot of people think that the binder, that
Mhm.
the power of attorney is part of the trust. No, it's not. These are separate documents. For example, different hats for different purposes or different tools for different purposes. And they're all designed to do this in summary. They're all designed to allow you to appoint a successor without having your affairs have to go through court processes to appoint a successor.
Excellent. So we covered the documents in brief, and I know this will probably generate a lot of questions, which is good. That's where you can talk to us. But let's talk about how I think you and I differentiate, which is the follow through and the education. So walk me through your process, not just in terms of preparing the documents. I think we already
Sure.
covered at least what they are, but more on what do you do differently? And I think really it's about education and follow through. So go ahead and
Well,
talk about that.
step one with us is we're going to educate our prospective clients on the issues that we're faced with. Okay. We're going to talk about what happens if you put documents in place. What's the alternative if you decide not to put the documents in place? I am confident in knowing that people that hire us know exactly what documents they want based on what problems that we discuss they want to avoid or address. Okay. Obviously, the documents are going to be prepared according to their instructions. And we do documents nationwide, including the preparation of the deeds. Okay. So we're a thorough planning firm that can get everything done for the client. Documents are put in place. They are explained how the documents work. Okay. It's not a hard process. Once the client has executed their documents, execute just means signed and notarized. Okay. After that's done, we give them the education, work with financial advisors of theirs to make sure all their accounts are either in the name of the trust or the financial power of attorney gets on record with the custodian. So we have them all buttoned up. We even give some of our families guidance with an online vault that they can store these documents in. So family members that aren't local, if the creators of the plan want their kids to know about their details, they can have access to it online. They don't have to ship hard copies all over the place. Last but not least, one of the neat benefits that we provide is after our clients get their plan in place, we invite them to get their successors all at the same table, and we explain process and procedure to the successors. We don't talk about how much anybody's going to inherit. We talk about process and procedure. So when the bad emotional times come, and if you don't know what I mean, when somebody has a stroke, heart attack, bad accident, or dies, that's not the first time the family successor is getting educated on what to do. Because, Logan, if it's a surviving spouse, I'm going to tell you something. I'm 53. I've been with the same woman since 16. We're business partners. If something happens to her, I'm not going to be all peaches and cream with the best thinking cap on. And I've been doing this work for 35 years. Imagine me being in that same boat and I don't know nothing about nothing when it comes to estate settlement. I'm in an extremely vulnerable position because of my emotional state. But if everybody's role played process and procedure, I'm more apt to be able to handle the estate settlement affairs, which, Logan, you mentioned something earlier. It's not complicated. Paying somebody's final bills and taxes is not complicated. Transferring assets from the trust to a beneficiary isn't complicated. It's just understanding process and procedure to get it done. And when they do, that really wraps up your planning tight because not only do you not have the permission slips in place, but your successors that you want to use those documents actually understand how to do it prior to any family drama.
And I try to do the same thing with my life insurance policies as I meet with the beneficiaries. Whoever the beneficiaries are in your policy, I want to talk to them now and walk them through the death claims process, which, just like you said, it's not complicated at all. It's very simple, but I want us to be having this conversation when you're not emotionally distraught. And I want you to know who I am and have my contact information. So when something happens, you're not calling a 1-800 number to file a claim. You're
That's right.
calling me, someone you know and have spoken to, and you know what the process looks like. The other thing that a life insurance policy really does for you, relevant to estate planning, is it buys you time to grieve properly. You will not have the sword of Damocles hanging over your head. There won't be any concerns about how am I going to pay for all this? What am I going to do? At least that, obviously, people who have not been through this don't understand the impact that finances can have on people in
They have
estate.
no clue.
Yeah, it really does. Finances really do. So knowing you have that death benefit protecting you buys you the time you need to really step away and grieve properly, right?
May I add something, Logan?
Yeah.
All right. And what Logan understands is when you have minor children, if God forbid the worst thing imagined occurs is where both mom and dad are dead, does everybody know that minor children can't inherit any of your money? And if you don't put more extensive estate planning in place, like a trust document, either a revocable trust while you're alive and competent, or Logan, some people are going to continue to use the testamentary trust, which means the estate has to go through probate before it's established. But either way, when you have the trust as a beneficiary of the life insurance proceeds, an adult is now in position to be able to use those life insurance proceeds for the benefit of the minor children.
And the same is true for life insurance policies that are on the children themselves,
100%.
because the children obviously cannot own those policies because they're minors. So someone needs to continue to own them, pay the premiums if there are premiums due, and so on. That probably would go to the trust. Um,
Absolutely.
so many of my
Absolutely.
clients are smart enough to have not only taken out whole life insurance policies on themselves and their spouses, but on the children too, which can be really valuable.
Exactly. Exactly.
Yep. So button it up in terms of follow through and communication. Then maybe if you have a couple of examples or stories or things to think about like real life scenarios that you've either seen or experienced or something like that to help people understand the importance of the documents and the follow through that we do.
The real life experience I see every day is denial that these issues are applicable to 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 almost everybody I talk to. There's a blind spot. I'll tell you the blind spot. You got an older parent and you're more concerned about their documents than yours. I want everybody to remember when you get on a flight and the flight attendant's giving you that speech, they don't tell you to put the oxygen masks on everybody else first. They say put the oxygen mask on yourself, then you help others. So one of the blind spots when I'm dealing with people my age that have aging parents is they aren't focused on their own plan, number one. There's a little bit of that denial. So I see that every day. The other area I see with optimism is that people are really holding on tight to, I have beneficiaries and everything. I have payable on death, transfer on death. I have a beneficiary deed that when I die, my real estate goes probate free. All of that is true. But what I said earlier is probate is just a reason to do estate, avoiding probate, excuse me, is one reason for estate planning. It's not the only reason because all of those items I just mentioned, Logue, beneficiary designations, etc., they all avoid probate, but they don't avoid problems, and I'll give them to you here pretty quick. You put a place a beneficiary deed. You've named your 3 children as beneficiaries. You die. They inherit the real estate. 2 want to sell, 1 doesn't. They inherit the real estate, but one of the children is going through a divorce, bankruptcy, IRS lien, or is being litigated against. Those are all problems now that those children are facing. And if the property was owned by a trust, they could have avoided the nonsense that is now going to occur because of leaving money a beneficiary designation just leaves money to beneficiaries without any ability to withhold distribution if that beneficiary isn't in a good position to inherit. By the way, Logan, if I could add just one more thing, a blind spot. The joint with rights of survivorship method of titling. I don't see what I'm going to talk about next happen as frequently as I used to, but it's still happening. And what's happening in some cases is I've got a surviving spouse, widow, widower, or maybe they've been divorced for a while, regardless, a single parent who puts a child, and sometimes children, but normally just one child, on the title of their real estate and their financial accounts as an owner. And they're doing that so that if something bad happens to the parent, that child has full control of the money, avoids probate, and now can distribute the assets maybe to their younger brother and sister. Here's the issue. And issue number one, the parent never thought about their child becoming incapacitated and not being able to manage their affairs. What I just said was, when mom or dad puts the kid on the title, they've given up control of their own asset. If that child, again, goes through bankruptcy, IRS liens, divorce, that asset is part of that child's problem. Okay? If the child wants to follow the parent's wishes for distribution, hear this. They aren't distributing the parent's money. The parent's dead. They've inherited the assets by contract, rights of survivorship. And if they decide to follow the parent's handshake wishes for distribution, they're actually giving away their money and not the parent's money. So the child is responsible for all the tax consequences incurred for selling real estate where they didn't get a stepped up basis, for dealing with the IRA or other assets that could have taxes built into it. What's my point, Logan? People are trying to avoid paying an estate planning attorney or a document firm somewhere between $2,000 and $10,000, let's say, for the planning. So they do it freebie, and doing it freebie ends up generating a lot more income taxes, probably 10 to 20 times in my examples, 10 to 20 times in income taxes over any fee they would pay to have the planning done properly and avoid all the nonsense.
Yep. It's like saying, I don't want to pay for an oil change on my car, so I'm just going to keep driving it without the oil change. And then your car breaks and you end up having to pay a massive bill,
Yeah,
buy a new car or something like that.
Hey, I would say that's a reasonable metaphor. Optimism. There's oil. What's the problem?
So, I agree with you. I see it a lot. People just, it's a hard thing to measure value. And so people latch onto something they can measure, which is how much does it cost? And then the lower the number, the better, and free is great. Of
That's right.
course, if you work with wealthy, successful people, they have the opposite attitude and they're not getting taken advantage of. Quite the opposite. They demand a lot, but they know how to measure value properly. And if you offer them something for free, that's when they get suspicious, right? Wait a
Absolutely.
minute.
Yeah.
I know how this works, right? Yeah.
I would like to offer something for those listening. Okay. If you ever have somebody say you don't have enough money to do estate planning, I want you to be brave enough to ask for details of why. And what I mean by that is the person telling you that you don't need to do anything, ask them to tell you exactly how your affairs will be settled upon your death or upon your incapacitation if you didn't do anything different than you're doing right now. Have them be very specific with you of the process, the time frame, and very respectfully, their fees. The mistake people are making is they will keep interviewing advisors until they get the answer they want. And the answer a lot of people want, Logan, is I don't have to do anything different.
Or it's free. I'll do it for you for
That,
free. Yeah.
okay, that's the message to people's ears. I'm asking you to get a little more detailed, okay? And don't allow any professional to say the fees are nominal or our probate process has been reformed, blee, blee, blee. Ask for details. And the details are, what's the process? How long will it take my affairs to be settled with my existing plan? And how much will your fees be? Every advisor knows the approximate time frame and the approximate fees when they know your situation. Do not let them backpedal and say, well, it'll depend. What's going to depend? Do you die with two beneficiaries nobody contests? How long and how much? Okay. Now, Mr. Logan, the reason most people can't do that is they've never been trained to be able to ask those specific questions. Now you have.
Yeah,
Okay.
and let's talk a little bit about changes. How often should they be reviewing this? If marriages happen, children are born, things like that.
Here's an opinion. Okay. Obviously, if you've got new beneficiaries in place, you'd want to update your documents. But here's a nice refreshing message to clients' ears. When you do this estate planning, every time you're buying and selling real estate or opening and closing financial accounts, that is not a change to your plan. Okay. That's just an addition or subtraction of an asset that's part of your financial life. Because, Logan, most people, they don't change their distribution. For example, if they have 3 kids, most people are equal to the kids based on whatever money's left over when the last parent is dead. So, when do you need to get your documents amended? If you change your mind on who's going to handle your affairs when you can't, or you change your mind on who gets whatever's left over after you're gone. That's when the documents need to be changed. Again, that new kid falls into a beneficiary designation. And beautiful question, Logan. I want to say this one more time. The buying and selling of assets, the opening and closing of financial accounts is not a change to your documents. Okay? So what I'm sharing with you is once you get your planning in place, if you don't change who your successor is or are, and if you don't change who's getting your stuff when you're gone, the only time you're going to be paying additional fees to your plan is if those things need to be catered to. Because when you're buying and selling in assets and opening and closing accounts, all you need to remember is if you have a trust, that you're taking the title in the name of your trust.
Let me throw out one more thing, funeral arrangements. Get those taken care of, have your cemetery plot, and have the pricing worked out in or paid for in advance because you will do much better. What happens is if you don't have that worked out in advance, it's just like anything else, right? You want to have that worked out in advance because you'll get a much better price.
Let me parrot it. Death's going to happen. And when you don't work it out ahead of the time, everybody's emotional. Everybody's emotional. And when everybody's emotional, they will spend more money, won't they, Logan?
Mhm.
They will
Yeah.
spend more money.
And
So,
funeral
very good point.
homes
Very good
funeral
point.
homes know this. Yep. So get it all worked out in advance. And I love the idea of intergenerational legacy planning and coordination among the families. This has an opportunity to open up those conversations. Again, we don't have to talk specific numbers, but just
No,
having a plan. This is what differentiates families like the Rockefellers and other old money, wealthy families that keep money in the family for generations, is that they have these conversations and they have these plans. Most American families don't ever have these conversations.
no.
Nobody knows what the plan is until someone dies, and usually they find out there is no plan, or at least no plan that was thought through and communicated with the rest of the family, right?
Even multimillionaires don't have their planning in place. Having money is not indicative of you thinking about succession if you become incapacitated or die. It's not a thought process people who make a lot of money are thinking about any more than those people that aren't making a lot of money.
Nelson Nash, in his book, encouraged us to think long range. And of course, this is not original with him. And when he said long range, he meant 3 generations into the future.
Sure.
And if you can think, I think most parents who have children can think in multiple generations. They can think about their children and you can set them up for success or you can set them up for failure based on planning like this, right?
And Logan, really good point. Every once in a while, I'll meet somebody that says, nobody gave anything to me. You know what my response to that is? And what does that got to do with you starting a new tradition in the Smith family? And that is the Smiths aren't going to be dead broke anymore.
And also, I would say, because what he's saying, I think what he's saying is, and I understand, I don't want to spoil my children. I don't want to just give them stuff. Great. That's what the
Sure.
trust is for. You can control everything. You're not giving money to a spoiled child to go spend it however they want. That's not how this
Exactly.
works.
Exactly,
If
sir.
if you read What Would the Rockefellers Do by Garrett Gunderson, which you should read, it's a great book relevant to this topic. It talks about estate planning and whole life insurance and a trust. You can control all of that. And the reason why the Rockefellers keep their money in the family is because the money is in a whole life insurance policy. And it's controlled by a trust, which is going to tell the children, yeah, if you want to start a business, will loan you some money on very favorable terms. But if you want to take a vacation, that's on you.
That's
Right.
right.
Yeah.
That's right.
So
Excellent point. People can actually build family legacies and address their concern that they don't want other beneficiaries to blow money that they worked very hard for and were diligent in accumulating to actually leave. Excellent point, Logan.
So that's pretty much all I had. Do you have some actual I know you do. I don't wanna scare the audience too much, but do you have some stories you use to get people's attention on estate planning?
Here, I'll give
I'm sure
you.
you got plenty of real
Well,
life
here's
stories.
here's
So
real life. Here's real life. I'm talking to the listener. You become incapacitated. Who's got access to your money and who's able to make medical decisions for you once you're stable? Okay.
I saw
That's
no, I know a story. I saw I didn't know them. It was a friend of our friend, but the father
yes.
had a stroke and was incapacitated, and they were having to do a GoFundMe because they could not get access to his money to
That's
pay
that
for anything.
that's facts. Once you've decided not to put your own documents in place, what you've really said is, I'm going to use the state of my domicile's documents. In other words, great point, Logan. You already have an estate plan in place. They just aren't your documents. They're the state of your domicile's document. Okay.
Right.
So Logan, the real world story is nobody's got control of your money if you become incapacitated. And married couples, when I talk about this, they're shocked. The quick story I give them is Mike and Stephanie. If something bad happened to you, Mike, and you got in a serious accident or had a bad illness and you're now incapacitated, how does Stephanie get access to your IRA or 401k? How does she make a real estate or a business transaction for you? And once you're stable, what's her permission slip to make further medical choices for you? And some spouses think because they're married, that gives them the legal right to do all of it. Other spouses will say, I'm Mike's beneficiary in his financial accounts. First and foremost, you don't have a legal right to make a decision for another adult unless they've given you permission in a document. And number two, I'm a beneficiary works at death, not incapacitation. So Logan, as far as the story, that scenario that I described to you is probably the biggest blind spot in the people that I'm educating that they have with regards to estate planning. Okay.
So in my framework, I have my little pyramid. At the bottom is protection, savings, investing, speculating. That's how it goes up the
Sure.
pyramid. And
Sure.
part of protection is estate planning. So it's not hard, it's not complicated. It's just one of those things you have to do and follow through. So you got the financial power of attorney. Let's make sure we file it with the financial institutions. You named a successor. Let's make sure we educate the successor.
That's
That's
right.
where Mike and I differentiate. We're not just going to give you a document and then say, have at it. We're actually going to help you get it done.
These documents, I like your word protection, but I'm going to add another word that'll resonate. This is foundation planning. It's the part of the money planning that is absolutely necessary, and I'll prove it. If you were having a house built and the crew digging and putting your foundation in, even with your uninformed eye, you can see that there's cracks in the walls and things like that. You would say, no way am I letting you continue with that foundation. You would want it perfect, something strong, because that's what gets you through the winter storm, not the pretty kitchen cabinets. Another analogy, you have a beautiful fruit orchard. The fruit that those trees are producing is because of the strong roots of every tree or the foundation of the tree, the thing you can't see that produces the beautiful benefits. A proper estate plan produces those wanted benefits at the most troubling emotional times in people's lives. And that's when they're dealing with somebody they love or strong like with their incapacitation or their death.
Offense wins games, defense wins championships. And the irony is, if you want to go and play offense, when you set up your foundation correctly, it puts you in a position to play offense much more safely, knowing you have the foundation.
Couldn't
So
have said it better. Perfect.
thanks so much for your time, Mike. We greatly appreciate it. We'll look forward to maybe talking with you some more. Thanks, everyone. The action item is schedule time with me. I'll put my Calendly link down below if you want to schedule time and talk estate planning. Mike and I work very closely together. Thanks for your time, Mike. Appreciate it.
You're welcome. Thank you.